and have not been permitted entry yet. If not, I can text one of them because I know that they know about today's court date.
Judge, I just spoke to Ms. Johnson. I think she's in your waiting room.
Oh, all right. Hold on. That's possible.
Yes, sir.
So is Miss Fand, if you wouldn't mind letting her in.
I've got a lot of people in there, so I'm just going to recall the case. Okay. All right, I'm calling a case from the 10 o'clock docket now. This is Eboni Wiley, 14 CF 7132. Look, actually, hold on. There's still at least one person connecting audio. All right, I think we're ready now. Let me get appearances on Eboni Wiley.
Dalton McKeever representing Ms. Wiley. I'm standing in for Rocky Brancato.
An appearance for the state.
Judge, Mr. Harmon.
Okay, Mr. Harmon may be muted.
Sorry about that.
Okay.
All right, I was going to say, Your Honor, Scott Harmon and Jennifer Johnson, assistant state attorneys on behalf of the state of Florida.
Okay, where are we on this case?
Judge, we have a plea agreement before the court, and I will read the terms out just for the record. It's going to be a guilty plea in her best interest. The state attorney's office has agreed to a sentencing cap of 6 months county jail, followed by 5 years of probation. And for the sentencing hearing to be heard on December 18th, 2020 at 12:30 p.m. in Judge Samantha Ward's division, Trial Division 3. She's agreed to preside over the sentencing hearing because of the length of the hearing and has asked that this case be transferred to her division. And I believe that's with the consent of the state, the judge, as well as Mr. Brancato and his client.
So is the understanding that I'm taking the plea now and then she'll sentence, or that I'm just transferring it all to Judge Ward and she'll take the plea?
You're taking the plea and then the sentencing will occur over there.
Okay, is that state's understanding also?
Yes, sir.
Okay. All right, Mr. McKeever, can you verify the identity of Ms. Wiley?
I can, Your Honor. I personally met with her, so I can recognize that as Eboni Wiley.
Any objection or issue or any questions from the state relating to her identity?
No, Your Honor. I have viewed her on the Zoom link, and it appears to be Ms. Wiley.
Do you object to the court taking this plea by Zoom, and do you object to the court swearing her in without a notary?
No, Your Honor.
No objection either.
And you've got all the forms, Madam Clerk? Okay. Ms. Wiley, please raise your right hand. Do you solemnly swear or affirm testimony you give you the truth, the whole truth, nothing but the truth?
Yes, sir.
You put your hand down. Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Do you have any mental health condition that prevents you from understanding my question?
No, sir.
Do you read and understand English?
Yes.
Did you read and understand the plea form?
Yes.
Do you understand all of the rights listed in the plea form?
Yes, sir.
Do you understand that you are giving up those rights by changing your plea?
Yes, sir.
Do you understand you're giving up the right to a jury trial?
Yes, sir.
You understand that you have the right to enter your plea in person, in court, where you're in the same room with me. Do you understand you're giving up your right to do that?
Yes, sir.
Are you giving up those rights freely and voluntarily?
Say it again, sir.
Are you giving up those rights freely and voluntarily?
Yes, sir.
Has anyone forced you or threatened you in order to get you to change your plea?
No, sir.
Have you been satisfied with the service of your attorney?
Yes, sir.
Is there anything your attorney failed to do to help you that you think should have been done?
No, sir.
Do you know of any other depositions that should have been taken in this case?
No, sir.
Any other witnesses who should have been talked to?
No, sir.
Any other investigations that should have been done?
No, sir.
Any other any tests that should have been conducted or experts who should have been retained?
No, sir.
You understand you're giving up the right to make any type of investigation or continue any discovery in this case. You're giving up any defenses that you could raise in this case. You're giving those things up forever. Do you understand that?
Yes, sir.
All you're left with at the end of this is the ability to appeal the sentence of the court. Do you understand that?
Yes.
You need any more time to talk to your attorneys about this case?
No, sir.
Do you understand if you're not an American citizen, changing your plea will lead to your deportation?
Yes, sir.
The charge in this case is providing false information to law enforcement during a missing person investigation involving a child. Do you understand that charge?
Yes, sir.
Punishable up to 5 years in Florida State Prison. It's a third-degree felony. Do you understand that and the maximum sentence that you would base on this charge?
Yes, sir.
Will the state provide a factual basis?
Yes, Your Honor. Your Honor, the state is prepared to prove that on May 16th of 2014, this defendant, along with an individual named Granville Ritchie, picked up Felecia Williams, who was 9 years old at the time, at her home on Ida Street in the city of Tampa. They then took her into the city of Temple Terrace, where they went through a drive-through at a fast food restaurant, and then on to an apartment at the Doral Oaks Apartments on Bullard Parkway and 56th Street in Temple Terrace, which is within Hillsborough County. Several hours later, this defendant reported Felecia Williams as being missing to members of her family. Later that evening, around 10:30, the defendant was requested by Felicia's mother to respond to the corner of Bullard Parkway and 56th Street in Temple Terrace, where the defendant came into contact with Deputy Daniels Tolber of the Hillsborough County Sheriff's Office. A missing persons investigation was ongoing at that point as to Felecia being missing. The defendant gave false information as to the circumstances leading to Felecia becoming missing to Deputy Daniels Tolber. Over the course of the next 20 hours going into May 17th of 2014, and during multiple interviews with Temple Terrace PD, Detectives Elmer, Ramirez, Carroll, and Staley, as they continued to investigate this missing persons report involving Felecia Williams, the defendant continued to lie and give false statements to these investigating officers. All of those events occurred within Temple Terrace in the county of Hillsborough. Felecia Williams, who was the subject of the missing persons investigation, was located at approximately 3:30 p.m. the following day on the 17th. Her lifeless body was found floating against the north shoreline of the Courtney Campbell Causeway. She had been raped, beaten, and strangled to death. The state is prepared to prove that the defendant is the person who made these false statements concerning this missing persons investigation.
Ms. Wiley, do you understand those are the facts you're pleading guilty to?
Yes.
You are, it's understanding the court that you are entering an open plea, but that the state attorney's office has made a promise to you, and that is that you will not be sentenced to more than 6 months county jail followed by 5 years probation. Is that your understanding?
Yes, so no more than 6 months, yes.
No more than 6 months jail and 5 years probation. You understand that?
Yes, sir.
So do you understand what an open plea is?
You can explain it a little bit more if you can.
Okay. An open plea is when you are entering a plea of guilty without a specific agreement on what your sentence is going to be. Now, in this case, there's an agreement that you're agreeing with the state attorney's office that you won't be sentenced to more than 6 months county jail and 5 years probation. But you're not entering a plea with any more of an understanding on what your sentence is going to be than that. Is that your understanding?
Okay, yes, sir.
So, so that your sentence in this case would be up to 6 months county jail followed by 5 years probation. It couldn't be worse than that, but it could be that. It could be 6 months county jail followed by 5 years probation. You understand that?
Yes, sir.
Has anyone told you that you're not going to get the full 6 months county jail followed by the full 5 years probation?
No, sir.
And so the Judge Ward's going to do the sentencing in this case. And so, of course, she'll listen to both sides. But at the conclusion of that, she may sentence you to 6 months county jail followed by 5 years probation. Do you understand that?
Yes, sir.
Have your attorneys told you that you're going to get something less than that?
No, sir.
Has anyone told you that you're going to get something less than that?
No, sir.
Has anyone told you, made any type of promise to you at all other than the sentencing cap? Has anyone made any type of promise to you on what your sentence is going to be in this case?
No, sir.
Anything else the state wants to put on the record?
Yes, Your Honor. There was a waiver of physical presence in court form that has been filed by the public defender and signed by electronically by the defendant and by her attorney, Mr. Brancato. Contained in that waiver is a certification that fingerprints, and there is a set of fingerprints that appear to be Miss Wiley's. Her name, her signature is on the form containing the fingerprints that is attached to that form. She is certifying within this document that indeed these are her fingerprints and that they are contained on this form. I would just ask the court to have the defendant acknowledge that on the record.
Ms. Wiley, did you sign those forms?
Yes, I did.
Did you have your fingerprints taken?
Yes, sir.
And did you sign the plea form?
Yes, sir.
Did you sign the form that waives your physical presence in the courtroom?
Yes, sir.
And did you give consent for your attorney to file all those documents?
Yes, I did.
Is there anything else, Mr. Harmon, you want me to ask about that?
No, Your Honor.
Is the sentencing cap any objection from the victim's family on this agreement with the sentencing cap, Mr. Harmon?
I believe there is an objection from the victim's father and possibly her mother.
This is her sister. My mom's not on here right now. I've been texting and calling her, but because when I first got on, it was like messing up. So I don't know if she was able to get in. So I'm just going to speak for her on anything. And then I'll just let her know.
Who's your mother?
Felecia.
Okay. Is that Ms. Demerson? She's
Yes.
there. She's there.
Okay.
So Ms. Demerson, you can unmute your device. Go ahead. If you want to be heard, you can, Ms. Demerson.
Okay.
Do you want to be heard, Ms. Demerson?
That's how you want to speak? That's how you want to speak first? Okay. Can you hear me?
Yes.
Okay. I'm willing. This is, to Eboni, Mr. Harmon. Today is a new day for everyone, but not my sugar plum. Today, my daughter would be 15 years old, 2 months away from being 16, sweet 16. A sweet 16 she will never see. I should be making her hair appointment, saving for a birthday outfit, and being stressed about how we going to afford this party. Instead, I am stressed about the consequences of you, Miss Wiley. You seem so poised and convinced you didn't do anything. Sugar Plum never even made it to 10 years old. Because she trusted you and an adult she loved, went to church with, and listened to, she didn't deserve the punishment she received. My baby was treated like an animal, folded up in a suitcase, while you, Miss Wiley, was lying to my older daughter, Temple Terrace police, and most importantly, lied to me. While my daughter was tucked away maliciously, Eboni, you had sex, you smoked weed, and you supposedly prayed. Prayed to who? Praying for what? Definitely not to the same God I serve. Why did you leave her with this man you just met? Why was my daughter not a priority. I have to live with the new normal of never seeing my daughter. I am left with my feelings of regret that I carry to my daughter's grave every day. I am very protective of my children, but there is one child that I will forever feel as though I failed. I didn't do anything wrong. My daughter didn't do anything wrong. But today, we are the only ones punished forever, while you are punished for 6 months. I'm left with memories of a sweet baby girl that I can only imagine who she would be. 6 months have came and went over and over during these past 6 years. I still have not processed this whole thing. So that is not enough time for Ms. Wiley to understand the magnitude of what she has done. You consider Eboni a star witness. I consider her a star player in the death of my child. My daughter may only be a case number to you, was a necessary part of me living every day. I can't sleep. I struggle to celebrate with my other children because I'm missing a child. Eboni, my daughter trusted you. She knew you, but she didn't know that her killer. Why was she left with this man? I will never understand. I know 6 months is not long enough for me to process this situation, this sentence, this mindset of Eboni, who is offered this 6 months slap on the wrist for taking away my baby girl forever. How this is acceptable? If there is nothing you all can or will do today, I will do something. I will fight for the laws to change so no one else has to feel what I feel today, helpless. I'm not satisfied with this outcome. I will not rest until something changes. Thank you for your time.
All right. Thank you, ma'am. Mr. Harmon, is there anyone else that anyone else from the victim's family that wants to be heard?
Judge, I don't know if Felecia Williams' father is on the Zoom link.
Let me just say, is there anyone else on the Zoom conference from the victim's family that wants to be heard?
Hey.
All right.
No,
Yeah, who said hello?
I just don't appreciate how you came to me when you knew that my sister was missing. You looked me dead in my face as if you did not know where my sister was, and then like you hard down prayed with me as if like you really did not know what my sister was. Do you know that I found that after my sister was killed that me and you is cousins? Like how I'm supposed to feel to know that my cousin killed my little sister or has something to do with my little sister being killed? And then you just walk around here like it ain't nothing. And I'm going to let you know, I am looking for you. I'm looking for you.
All right.
I'm looking for you.
You're for the record, the Ms. Demerson is the victim's mother, and from Charlicia's iPhone, that's the victim's sister.
Yes.
All right. Thank you. All right, Mr. Harmon, it sounds like the victim's family objects to the cap. Is there anything that you want to present to the court on why the court should accept the plea with subject to a cap?
Your Honor, I would point out to the court that the defendant had no prior record, and the primary offense on the score sheet is an offense level 3. So there were only 16 points. She does not score higher than 364 days in the Hillsborough County Jail as a maximum incarcerative sentence, and 5 years probation is a statutory max. This defendant did cooperate with the state and did testify against the individual, Granville Ritchie, who raped and murdered Felecia Williams. And she cooperated during preparation and gave a deposition.
All right. Is there anything else? Anything the defendant? Anything from counsel for the defendant?
No, sir. Nothing additional to what Mr. Harmon said.
Were they, when the during the course of this trial, were there any promises made to the defendant relating to her cooperation, testimony, and deposition?
No,
Judge,
Your Honor.
I was going to say, I can't speak to that. I was not there. Mr. Brancato has handled that case for those proceedings.
Okay. So no promise or agreement was ever made to her in terms of getting this cap if she gave truthful testimony or anything like that.
That's correct, Your Honor. She testified without any type of an agreement with the state, with pending charges.
All right. All right. Well, I'm inclined to permit the open plea subject to the cap. I mean, it sounds like based on her score, she'd only score a maximum of 1 year county jail, followed by the remainder probation. So this isn't too far from what she would score, and based on her cooperation during the investigation and during the course of Mr. Granville Ritchie's case, the court would find that that's a reason to accept this cap, which again isn't far from what her score would be. So, Ms. Wiley, do you understand that the facts that were read into the record are the ones that you are pleading guilty to?
Yes, sir.
I couldn't hear you.
Yes, sir.
What plea do you want to enter for false information to law enforcement during a missing person investigation?
Guilty in my best interest.
The court will accept that plea, find that it's freely, voluntarily, and intelligently made, find that there is a factual basis to support the charge. And the court, per the joint request, the parties will transfer this case to Trial Division 3 for Judge Samantha Ward to sentence in this case. Judge Samantha Ward handled Mr. Ritchie's trial, so she'll be the one that will pronounce sentence in this case. Sentencing will be set December 8th at 12:30.
Judge, just for the record, actually, Judge Cisco presided over Mr. Ritchie's trial.
But this one's being sent to Ward and not Cisco?
I believe Judge Ward was suggested because of her availability.
All right. All right.
Correct. She had the day available, Your Honor, the full day for a sentencing hearing.
All right. If that's what the parties have agreed on, then that's what it'll be. December 18th, 12:30 with Judge Samantha Ward, Trial Division 3.
Thank you, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Next up, we've got Harold Edward Jackson, 20 CF 2511.
Your Honor, Dalton McKeever, I represent Harold Jackson. Ms. Ojeda, on her two cases, and just for the record, there were two others pending. I saw them on the docket today. I don't know if they still exist. The state filed null process on them. I just wanted to make sure the record reflected that. On 23653A and 20 CF 4890, the state filed written null process. So those pretrials should have been resolved.
What were the two cases with the null process?
20 CF 3653, the ag back rape bodily harm, and then the 20 CF 4890 felon in possession. Those have been null processed. A written null process was filed.
There's three remaining.
There's one remaining. 20 CF 2511 is the only one remaining.
Got it. All right. Now I understand.
Yes, sir.
All right. Do we,
Judge, he's in the Orient Road jail currently, so I would ask for him to be put over to Tuesday so he could be present for a colloquy. The last offer I did convey to him so the court is aware. The last firm offer was 1 year and a day, Florida State Prison. That is when the other two matters were still pending. Mr. Pruner had mentioned possibilities of other offers, but that is the concrete one that I have received unless something is